In this lecture, we would like to discuss Scandinavian realism. So, the Scandinavian jurists they developed the realistic theory in Scandinavian countries such as Sweden, Denmark, Norway, Finland, etc., which are considered as Scandinavian countries. So these jurists they developed their approach, which is considered as metaphysical skeptical. So according to Professor Allen, if American realism is ruled skeptic, the Scandinavian realism may be described as metaphysical skeptical. So it insists vehemently on the disassociating all legal phenomena from metaphysics, which Professor Alf Ross, following Professor Hagerstown, considers to be largely derived from primitive magic and on the regarding them as social facts ascertained by empirical science. So, according to the Scandinavian jurist, all legal concepts, whether it is right or duty or obligation or state sovereignty, all they consider as metaphysical concepts. So, law is not associated with these metaphysical concepts. So, they are entitled as a group of metaphysical skeptical. So, these metaphysical skepticals, according to them, law in all its form is a social reality and it is skewed of doctrinal jurisprudential conceptions like natural law, idealism, and metaphysical notions of right, duty, command, sovereignty, which are the pillars of either of natural law school or historical jurisprudence or analytical jurisprudence. So, according to them, law is not concerned with all these metaphysical concepts developed by the natural or philosophical schools, jurists or idealists, and according to them only law is in actual use, that is considered as the proper meaning of law. So, among the Scandinavian jurists, we would like to first discuss about the philosophy of Scandinavian realism as laid down by Axel Hagerstown. So, in brief, it could be said that he emphasized on actual use of legal concepts and their use in the involvement of mental attitude. So he rejected the right, duty, relations, and legal obligations. So Hagerstown is the father of Scandinavian realist movement in Sweden and was the professor of philosophy in the University of Uppsala, who greatly influenced the philosophy of Lonsted, Olive Kurna, and Alf Ross. As a storm sets out to destroy the notion of the right, duty, relations and legal obligations as according to have any objective existence. It was no more than a feeling which could be explained psychologically, and that is law. Similarly, he denied the existence of such things as goodness and badness, and remarked that they represent simply emotional attitudes of approval or disapproval, respectively, towards certain facts and situations. Further, Hagerstown denies the possibility of the science of art and says all questions of justice, aims, and purposes of law are matters of personal evaluation, not susceptible to any scientific process of examination. He pleads for an examination of the actual use of legal concepts and analysis of the mental attitude involved in the conception of law in the present times as it was opined by Hagerstown, as he was considered as the propounder and father of Scandinavian realistic movement in Sweden, and now we'll go to his disciple Lundstedt, who emphasized on social needs and pressures and the guiding motive of legal activities. So the very aim of law must be social welfare. So he rejected all metaphysical ideas. The general sense of security could be achieved on the basis of social welfare, and regarding the very general sense of security, he invented the doctrine of strict liability in tort. So, Professor Lundstedt is the most extreme of the three of the Scandinavian jurists and is extremely intolerant towards metaphysical ideas. According to him, nothing exists which cannot be proved as fact. He ridiculed at most of the English theories of law and rejected the idea of law. So also he rejected the means of securing justice, and it is not founded on justice but on social needs and pressures, according to Professor Lundstedt. Instead, Lundstedt says law at any time and place in any society is guided and determined by social welfare, which is the guiding motives for best possible legal activities. These are namely the encouragement in the best possible way of that which people in general actually strive to attain. So, judges should think in terms of social aims, not rights. According to him, the area of social welfare postulates general sense of security, which leads to him to expound the doctrine of strict liability in tort, contract, and criminal law to prevent social disruption. And the third important jurist belonging to Scandinavian Realist School is Olive Korna. So he emphasized that law is a set of social facts, and he rejected the command notion of the will of the state as developed by the analytical jurist like Austin. So he laid stress on independent imperatives as operating on the mind of the judge or judges would determine what exactly law means. So Professor Ali Kurna is the more acceptable among the Scandinavian realists who stress that law must be studied as a social fact, as already observed. Olipkona remarks law is nothing but a set of social facts. The rules of law are in no sense the will of the state in the sense of commands, but are independent imperatives issued from time to time by various constitutional agencies, and their sole effect is that they operate on the mind of the judge and lead to certain applications of law which are the facts of the legal system. And the last and the fourth important jurist of Scandinavian realist school is Alf Ross. So, according to him, he gave emphasis on the very conception of social reality, which should be determined according to the behavior of man in society. So, the very position of courts, he emphasized on the norms of conduct, which is behavior, and norms of competence, which is declared mode of procedure by the courts. So, behavior of courts is very important according to Professor Alf Ross. So, the very problem of the validity of law, as according to Professor Alf Ross's prediction that the court will apply in future the normative ideas developed by the past actual behavior of the judge. So, according to him, legal notions must be interpreted as conceptions of social reality, the behavior of man in society, and as nothing else. However, he dismissed however, Professor Alf Ross dismisses Lundsted's theory of social welfare as being metaphysical. Like the American realist, Ross tends to highlight the position of courts. So, according to him, the principal features of legal norms is that they are directives addressed to the courts. So, a norm may derive from past decisions, but it follows from this view that all norms, including those of legislation, should be viewed as directives to courts. Norms of law may be further divided as according to Alf Ross into norms of conduct which deal with behavior and norms of competence or procedure which direct that norms brought into existence according to a declared mode of procedure shall be regarded as norms of conduct. Thus, norms of competence are indirectly expressed the validity of law. So, this is the view of Professor Alf Ross. And regarding the very definition and meaning and the very origin and continuance of the concept of law. So, the view of the realistic school and their philosophical ideas could be better represented by the opinion of Professor Friedman, who in his legal theory expounded an universal, uniform opinion on the jurists of either American or Scandinavian realist school as that law must be conditioned by changing social needs. So, the very impact of Scandinavian realistic movement, according to Professor Friedman in his legal theory, that its main contribution has been to pursue the detention of open or hidden legal ideologies beyond the usual criticism of sovereignty, rights, and duties by implication rather than as a matter of articulate philosophy. The Scandinavian realists have demonstrated that any legal order must be conditioned upon a certain scale of values which can be assessed not in absolute terms but with regard to the social needs changing with times, notions, and circumstances. Whether law is described as a fact, as a machinery in action, or in any other manner, it is directed to certain ends, and that particular end is social needs and social pressure or social facts as the very conception of social reality and which would be determined according to the behavior of man in society and such as the position of the lawyers, law officers, and officials associated within the judicial process, the judges. So, yet the Scandinavian realist also laid emphasis on the independent imperatives which are operating on the minds of the judge or judges while delivering a judgment. So, all judgments are itself law. So, in this way, the Scandinavian realist rejected all metaphysical ideas either developed by the natural law jurist of natural law school, the historical law school jurist, so as they rejected command of the sovereignty and state, so they rejected all those legal notions and legal concepts developed by the analytical jurisprudence school, either by Bentham or Austin or by Professor Hans Kelsen and his pure theory of law. So, we have completed both American realist school and Scandinavian realistic school, and as they are identified as the left wing of sociological jurisprudence as because of their emphasis on social needs and pressures on social facts, so to some extent rightly they are considered as the left wing of sociological jurisprudence. So, we have completed both American realistic school and also the Scandinavian realistic school, which we have just completed in this lecture.